We've been talking a lot about the ATF's new pistol brace or stabilizing brace criteria for when a pistol becomes a short barrel rifle. Now, I basically have given you a headache with my discussion, although it's not my fault, it's the ATF's. With this video, I hope to give you a little bit of an aspirin to solve for the problem of the headache I've given you, thanks to the ATF. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms and help us get to 100,000 subscribers. We've been working really hard toward that goal, and we still have a ways to go. All right, folks. We've done a few videos, and I'm sure you all been reading about. The ATF came out with a new regulation, which in my opinion simply expanded the definition of rifle, specifically the definition of short barrel rifle under the National Firearms Act and the Gun Control Act of 1968, so that individuals that have handguns with so-called stabilizing braces, in many instances, may very well run afoul of the criminal law, at least according to the view of the ATF. We've talked about what the ATF, according to their 293-page description of what a short barrel rifle is when it involves a stabilizing brace. We pointed out before that that requires, according to the ATF, that you have a weapon coupled with some sort of stabilizing brace attached to the back, and that stabilizing brace attached to the back has enough surface space on it so that it can be touched to your shoulder, and thus that weapon can be fired from your shoulder. Those are the first three elements, and then of course there's those 6 factors that the ATF sets forth with no rhyme or reason as to how many of them you have to meet for it to be a short barrel rifle, at least in their opinion. And one of those, of course, is a crazy idea that you somehow are charged with the knowledge of what a gun manufacturer has done to market that stabilizing brace and or that firearm, which is simply absurd on its face. But I want to tell you, this is mission critical, okay? This is the video you want to send around because about what I'm about to tell you. We've talked about the headache here, the problem. I want to give you what I consider to be a silver bullet. There's several silver bullets when it comes to this regulation. We'll talk about it in other videos. But I want to talk about one specific one right here, right now. It's a Supreme Court case that I all want you to know about. In light of what the ATF has just done, I'm now giving you a quick assignment. You know you need to know about the Heller case. You know you need to know about the McDonald case. You know you need to know about the Caetano case. And you know you need to know about the NYSERDA versus Bruin case. Those are mandatory requirements if you support the Second Amendment to know those 4 Supreme Court cases. I am now going to add a 5th Supreme Court case that is mission critical for anyone interested in the National Firearms Act. You must now know. It is a 1994 case called Staples versus the United States. 1994, it was a 7-2 decision. The 2 dissenters are no longer with us. That's one Justice Blackmun and Justice Stevens. They're no longer with us, obviously. 1994, 7-2 decision, and included Ruth Bader Ginsburg in the majority, believe it or not. Okay. 7-2 decision of Staples versus the United States. This is a mission critical case, and I think is directly applicable to the pistol brace issue and whether or not the ATF could ever charge gun owners with illegal possession of an NFA item that's not been registered, okay? We'll see if you agree after you hear my analysis and look at the case, which I will cite to or put a link to down below. In the Staples case, you see Harold Staples had what he thought was a semi-automatic rifle. However, when he was arrested by the ATF was able to take that, what Mr. Staples thought was a semi-automatic rifle, and the ATF was able to make that rifle fire as a fully automatic weapon, thus a machine gun. Now, the rifle that Mr. Staples possessed was, in his mind, a semi-automatic weapon. The ATF said that Mr. Staples possessed a fully automatic weapon. So Mr. Staples said he had no idea this was a machine gun, or that this could be a machine gun, or that this could be fired fully automatic. The ATF said it didn't matter under the law, that as long as the ATF and the prosecutor could show that Mr. Staples had this firearm, and that the ATF could demonstrate that it was a fully automatic weapon as defined by the opinion of the ATF, Mr. Staples committed a crime, violated the National Firearms Act, and could go to prison. Well, this case went to the United States Supreme Court, and the question presented to the U.S. Supreme Court was, did the prosecutors, did the United States Department of Justice and the ATF have to prove that Mr. Staples knew, I repeat, knew or intended to own and possess a fully automatic rifle? Or did they simply have to, which was the ATF's contention, simply have to prove that Mr. Staples had such a weapon in his possession and that the ATF was able to make that weapon fire as a fully automatic weapon? Well, the great news here is, and this I think is devastating to the ATF's argument on this pistol brace issue, is that the U.S. Supreme Court said in a 7-2 decision, which included Ruth Bader Ginsburg, no less, in the majority, that it was the burden of the government to demonstrate that an individual criminal defendant had to know or intend, but had to know that he or she possessed an illegal firearm under the National Firearms Act. It was not enough for the ATF simply to say that the criminal defendant had that weapon and that it, in the opinion of the ATF, violated the law. That was not enough. The Supreme Court said that the defendant had to actually know with actual knowledge that the weapon was an NFA item and wasn't registered. Now, this is terrible from the point of view of the ATF and the pistol brace issue, because as we talked about in other issues, it is almost impossible, even for high-end lawyers, to understand what violates this law and what does not violate the law because of the ambiguity associated with this criteria that the ATF has set forth, and I've talked about in other videos. But I want to give you some of the powerful language from the United States Supreme Court. This is not my opinion. This is not some YouTuber talking. This is from the United States Supreme Court talking about what the government has to show to put you in prison for possessing an alleged NFA item. And they have to show you knew that this is an NFA item. At least that's how I read the case. You can check it out and have your lawyers check it out for yourself. So again, the issue is mens rea. Now, I just want to use the word mens rea briefly. It's a Latin term for intent. Under basic black letter criminal law, there's two elements in every criminal case. You have what's known as actus reus, which means you have to have an action of some sort. You do something. And then you have to have mens rea. Mens rea is your mental intent. For the purposes of committing a federal crime under the National Firearms Act, you have to have some sort of a knowledge intent. That's at least what the Staples decision from the U.S. Supreme Court says. The mens rea has to be that you knew or intended to possess an item that violated the NFA. Now let's go on, and here's some major quotes from the Supreme Court in this case. The court said that the National Firearms Act, quote, by itself does not necessarily suggest that Congress intended to dispense with a conventional mens rea element, which would require that the defendant, listen carefully, which would require that the defendant know the facts that make his conduct illegal, close quote, U.S. Supreme Court. You have to know the facts that make your conduct illegal is what the U.S. Supreme Court said in Staples. Indeed, the U.S. Supreme Court continued, quote, the existence of mens rea, remember that's the intent requirement, it's the Latin phrase for the intent, the existence of a mens rea is the rule rather than the exception to the principles of Anglo-American criminal jurisprudence, period, close quote. Again, the Supreme Court says that you have to show that a criminal defendant to violate the NFA has the mens rea necessary to be put in prison, and mens rea just means the intent, the knowledge requirement, that you knew that you were doing something wrong and violated the criminal law, okay? Now, the Supreme Court goes on to point out that gun ownership in the United States is long-standing. I want to remind you that this was in the year 1994. This is literally over a decade before the Heller decision. So here's what the Supreme Court said in Staples in 1994. There is a long tradition of widespread lawful gun ownership by private individuals in this country. Such a tradition did not apply to the possession of another case we dealt with, dealing with hand grenades, Supreme Court's drawing a distinction with a hand grenade case. They said in the hand grenade case, we construed the NFA under the assumption that one would hardly be surprised to learn that possession of hand grenades is not an innocent act. So here the Supreme Court in Staples is pointing out that the mere possession of a firearm is an ordinary act. They say long tradition of widespread lawful gun ownership by private individuals in this country. That's in contrast to possessing hand grenades, as they were pointing out, that it's kind of unusual, and that would be suggested that you may need to, that maybe they would loosen the intent requirements. But when you're dealing with firearms, you can see the presumption is that you're lawfully possessing them. The Supreme Court continued on and said, quote, guns in general are not deleterious devices or products or obnoxious waste materials, close quote. That's what the Supreme Court said back in 1994, before all the other favorable Second Amendment precedent we all know about. Now, this is very interesting. The United States Supreme Court took to task the government's position, the Department of Justice position. And in this language I'm about to read to you sounds like it's directly applicable to what I could see a court saying to the ATF today. Here's what the U.S. Supreme Court said, 1994. The government's position, tell me if you think this rings true today, 1994, but tell me if it rings true today. The government position would be, quote, would impose criminal sanctions on a class of persons whose mental state, ignorance of the characteristics of weapons in their possession, makes their actions entirely innocent. That's right. The government's position would impose criminal sanctions on a class of persons whose mental state, which is ignorance of the characteristics of weapons in their possession, makes their actions entirely innocent. Period, close quote. The Supreme Court then says, under that view of the government, any person who has purchased what he believes to be a semi-automatic rifle or handgun, or who simply has inherited a gun from a relative and left it untouched in an attic or basement, can be subject to imprisonment despite absolute ignorance of the gun's firing capabilities if the gun turns out to be an automatic, close quote. This is what the Supreme Court is saying. This is highly relevant to the pistol brace issue because the Supreme Court said that if you don't know that the gun that you have in your possession is a fully automatic weapon requiring registration of the NFA and not registered with the NFA, if you don't actually know this, the government can't put you in jail for a crime because you have to have the mens rea requirement satisfied. And in the context of the National Firearms Act, as the Supreme Court points out here, when you're dealing with firearms, the mens rea is you have to have actual knowledge of the characteristics of the weapon in your possession. Now, I think the reason why this is so relevant to the pistol brace issue is that, again, the ATF is proposing this multi-factor test, of which many of those examples we've talked about, elements, are vague and ambiguous, in my opinion. Remember, the definition of vague and ambiguous is if multiple people could reach different conclusions about the meaning of a term that are all reasonable. So you have contradictory opinions or contradictory views of the language. And I think that's certainly the case that I could see high-end lawyers, judges, law clerks, and the like, disagreeing about whether or not a particular handgun with a stabilizing brace attached to it, whether that's an NFA item, meaning whether that's a short barrel rifle or not. I could see reasonable people disagreeing with us all the time. And now it's subject to debate. It's vague and ambiguous. And because it's vague and ambiguous, I would argue under the Thompson Center Arms case before the Supreme Court, the rule of lenity applies, which means that any ambiguity falls down in favor of the private individual and against the government. Rule of lenity, Thompson Center Arms case, argued actually by Stephen Halbrook, who's been on the show before. Now, keep in mind that it's my understanding that aftermarket pistol braces are still legal. You can still buy them. The ATF has apparently changed its mind for many, many years, going back to, I think, 2012. It said a lot of these pistol braces, when attached to handguns, do not convert those handguns, those pistols, into short barrel rifle NFA items. So now they've flipped their view. I think an average gun owner is going to be completely confused as to whether or not a handgun with a pistol brace attached is a short barrel rifle, because I'm not sure. I don't have one. I don't own any of these things. But if I did, I'm not even sure I could figure out whether or not this meets the definition of short barrel rifle as set forth in the 293-page explanation by the ATF. And of course, my basic rule is if you need 293 pages to explain something, it ain't going to be that clear. It tells you that by definition, it's not really clear. That's just my opinion. Okay, so the bottom line is this. I want you to take a look and make sure you show your lawyers that you're working with. If you have specific questions, obviously check with your own lawyer, your local counsels, who are much better positioned to tell you what to do than I would ever be. I'm not like a gun expert. There's a lot of people much better on guns than I am. I'm really just a constitutional law guy. But I am taking time to talk about this pistol brace issue because I know it's a big deal to the Second Amendment community. And I'm trying to add some observations that people can maybe consider as they move forward with this. But again, you need to read very carefully and bring to everyone's attention Staples versus United States. And I should mention, I have looked carefully through the 293 pages of the ATS regulations. And do you know what's not cited? Do you know what's not flagged or mentioned in 293 pages of spilt ink by the ATF and the DOJ with their billion-dollar budgets? That is a citation to the Supreme Court case from 1994 of Staples versus United States. One wonders whether or not ATF was trying to pull a fast one by hiding it and hoping that no one noticed. And maybe no one would have noticed, but perhaps they weren't anticipating that Mark Smith and the Four Boxes Diner would actually read their document word for word. Okay, I hope you learned a little bit something here at the Four Boxes Diner. If you haven't subscribed, please do so. Make sure you check out the Staples case, link down below, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.